All rise. Yes, Miss Scriven.
May I take up our questions by looking at the Family Proceedings Court reasons in the core bundle 32, 33, 34. I was making the point in relation to 14 of what are described as the findings, that was the place where one would have expected to see some assessment in relation to the father, but that in fact that is really not made at that stage.
If one looks at the pro forma that justices are expected to fill in, which we were presented with this morning, you will notice that it is matters in dispute and our corresponding findings of fact is the heading.
Could your ladyship give me just one moment to turn up the page? Thank you. Yes.
Yes, but this is a standard form.
Yeah.
May even be prescribed by the family proceedings. Well, the magistrate's version of the rules. Wouldn't surprise me if it were. I haven't checked.
No.
But one notices that it refers to matters in dispute. It wasn't in dispute that there was a relationship, and a good relationship, between this father and his son. So I'm not sure that I would expect this form to deal with that, the rather more subtle things that you're complaining that no court, as far as I know, has ever dealt with. The subtle things in Re G, which have frankly been taken for granted for courts, without anything. So it's a bit hard on these poor justices to start criticising them for not doing something that most of the higher courts never did.
And in fairness to AW, he does deal with these points, even though he doesn't deal with them quite in the terms which you suggest he should. On page 42, when he talks about the father's commitment and motivation, and the grandmother's motivation also, and then he talks about family members all being committed to him.
Yes.
And so he's obviously got in mind the family relationships.
He begins the process, but he doesn't conclude it. He doesn't properly assess it from the point of view of the child and the child's welfare needs.
In one view, what more needed to be said? Given that this is not a legal document, and given, as my Lord Clerk said, much of this is to be taken for granted.
Well, my Lord, we would submit that there ought to be a discussion in there of the relationship between the father and the child, the significance to the child of that relationship, the attachment, the importance to the child potentially of living in a home with his father and his half-sibling.
It is noticeable that he never at any point says that he saw this little boy.
No.
It may be that he did. And it may be that he saw this little boy interacting with both grandmother and with father. But it may be that he did not. I mean, that's the criticism I would make.
Absolutely.
I mean, you're putting it in highfalutin language, but basically what you're saying is Even though-
Well, yes.
Yeah.
But he visited them. He visited everyone at home.
Yes, I'm told that he did not see. He saw my client and his wife and interviewed them both. He did not see them with the child. I mean, absolutely critical part of the assessment process
So he
just not done.
He saw the child with the grand.
I don't know.
Well,
I have no idea.
Or did anybody ask him to?
One would have. I don't think in terms that they did. One would normally expect that would be done. As
But
my,
surely,
my lady
if one's going to
has
take this
just
sort of
said.
point, it ought to be taken before the justices. It's all very well to come to the Supreme Court and take the point. But, I mean, if any party wants the Section 7 reporter to see the child and he or she hasn't, surely the time to take the point is at the beginning. And it may sound a rather technical point, but here we are, months and months later.
I know. The way that I would put the response to that was this. I gather that, in fact, the Section 7 reporter paid his visit to see the father and his wife on the day before the report was written. It was obviously done in a short time frame. At one point in the evidence, he talks about the number of reports he was doing at that stage. And then, of course, the parties get to court and try to do their best to reach some resolution of the case. There's always that pressure. So the counsel of perfection might have been to say, well, stand up and make an application for an adjournment so that he should see.
Yes, but if you
the
don't
child.
do that, I quite see that might be a counsel of perfection, but la vie c'est comme ça. Once this is the process that's gone on, it's a bit much to sort of complain about it later. We have to, surely everybody has to do the best with what we have.
I have not put that in my case because I had not thought it was, as it were, right to take now for the first time a point that wasn't taken before. But what I do say is that this is part of the process by which this Section 7 reporter has fallen into error and not conducted the proper evaluation of the father and the child. And you can see that because the report is so sparse on information about it. And one can see that because there's no discussion in that report of that potential importance to the child and the significance to the child.
Are you going so far as to say that a Section 7 reporter, if he's to pass comment on these relationships at all, would need to observe the child with the relevant parent or grandparent?
I would have thought it would be a rather useful starting point.
But
Yes.
of course, let's not lose sight of the fact that this child was just over 3 years old at the time.
Yes.
Whether one can reach a reliable, much less an infallible judgment on seeing a child of that age react with an adult, I personally would question.
Yeah. He does say on page 43, child's too young to express any wishes and feelings.
Yes.
I mean, obviously that means question and answer isn't going to get you anywhere. And it's an assessment that the Section 7 reporter has to carry out for himself or herself, whether this is the kind of case where it's really necessary for me to go that further step, because one has to face the fact that there are pressures on these people. They've got a lot of work to carry out.
There are, of course, two different things. One is whether a child can give a useful answer to a question about where he or she would like to live, which requires a certain maturity. And certainly how the court will look at it will be in the context of everything else that the court knows about the child's life, the dynamics, possible pressures on the child's level of maturity and the like. With a 3-year-old, it's quite clear you're lower than any possible starting point of asking the child for an expression of view. But there is a different question, which is gauging the quality of the attachment and the nature of the relationship, which one would have thought would be one of the things that a Section 7 reporter would help the court with.
Well, we've got a problem, haven't we, really, if we're looking at this realistically. Were this to be a wardship case in the High Court, in the olden days, the official solicitor would have instructed a child psychiatrist to report to the court And that child psychiatrist would have spent considerable amount of time observing the child in the relationship with each of the three parties concerned. That's what they routinely did. You have to spend a considerable amount of time to form any sort of reliable judgment, one would have thought. Certainly you can't just do it instantly. And so one has to say, well, is that kind of Rolls-Royce treatment to be applied to every grandparent-parent dispute? I mean, one might reach that view, in which case they certainly shouldn't be in the Family Proceedings Court, and a larger quantity of resources should be devoted to them. Or does one take the view, we are where we are, and we are in a situation where it's acknowledged on all sides that there are good relationships. The reasons that I gave in 3G for why fathers and mothers are important to children are common knowledge. This is not rocket science. So is one being realistic in criticising a Section 7 reporter for not saying, of course I've taken into account A, B and C are important things about the relationship between a father and child, when he has taken into account the fact that there are good relationships all round? Sorry, long question, but I'm...
Yes. Well, in fact, if I may say so, that was a point I wanted to draw to the court's attention, because he says there are good relationships all round, so he's not actually providing any sort of analysis of what is and is not useful, beneficial and the like to the child from those relationships. One can't distinguish between grandmother, mother and father on that basis. So that's not... we would submit actually helping deal with the basic problems.
But if this is the key point, we'd expect to see it in the cross-examination, wouldn't we? If we look at the evidence at page 120, 121, 122 and 123, and then one can endlessly analyse these issues, no doubt, and they can become ever more refined in appellate jurisdictions. But in real life, if these points are live, they've got to be addressed at first instance. Well, first of all, we have the cross-examination on behalf of your client, starting at page 120, I think, roughly.
I thought it was earlier, wasn't it?
Maybe it starts a bit earlier.
Yes,
yes, probably 118.
It's 108, I think, isn't it?
Oh, well, that's
right?
I think that's the
different note, yes.
the other note.
The earlier ones are taken by the Magistrates Court Clerk.
Yeah.
The ones that start on 108.
Sorry.
And then there's a set of
Yes, I
solicitors'
see.
notes
Yes,
that
you've got
follow.
But I was just happened to be looking at the second one. But I
Yes.
think they're account of the same examination, aren't they? It's just
Yeah.
So it's 118.
begins at 118, and various questions are asked on all sorts of topics. And then the sort of point you're making, perhaps, is covered on page 120. The positive things in relation to the father. Nothing quite on the specific point you're making, although she is asked then, or he's then asked some questions by the counsel on behalf of the mother on page 123 and 124, where there's quite a lot of discussion about his emotional development and the attachment to the father in that context. And surely the sort of points you're discussing were at least ventilated. Perhaps not with the sophistication as they would be if you'd been there yourself, but in a broad sense ventilated. And as my lady said, it isn't in a way rocket science. It is ultimately it's a stark choice. And so if anybody was going to be criticised, it would be counsel at the time. But to my mind, wouldn't be fair to do that because the issues were really understood by everybody, and most of the relevant questions appear to have been asked and answered.
And so one can see, for example, in the other note, the Magistrates Court note 109, which is Miss Parnell's cross-examination.
Yeah.
She asked questions, first of all, about the concerns about the grandmother, and then moves on. Move to Dad's address handled sensitively, no reason why it shouldn't be successful. point I've already taken the court to. I'm clear Mr. Babbs can meet needs. Last offence was in 2006. He's put it behind him. Stable relationship, not involved in criminal activity. Actually, relationship with son is good. Being in prison would have interfered with his relationship with son. Since then, he's moved on. Shows remorse for what he did and the impact on the child. Aware child stayed with him for significant time when grandma ill. He's taking steps regarding accommodation, schooling for Harley, which are appropriate. It's appropriate for the child to live with the biological parent. Then he says balance with grandmother and the like.
Yeah.
And then he goes on at the bottom of the page, Babs, like, I'm so sorry, I've run into error there. Likely to have longer relationship with son. Son needs close relationship. So yes, there were questions in cross-examination, but they were not matters that were identified in the report at all. It was only in the course of the hearing that these matters were first even apparently considered.
As long as they were considered. I mean, it doesn't matter really, does it, whether they were in the report?
Well, with respect, we would submit that what the magistrates did was to actually fall into a similar error to the judge in Re G, which is that actually there was no proper consideration by the magistrates in their thinking process of the importance and significance of the natural father in this child's life.
To reach that conclusion, we would have to conclude that they left out of account the evidence that you've just referred to.
Well, that there is absolutely nothing to show that they did take it into account.
Actually, of course, if we're talking about Re G was a case in which the judge had removed the child from primary care.
Oh, absolutely, yes, of course. It's not the same factually. I appreciate that. But what I am...
That's a fundamental fact, Ms. Whittam.
Of course it is. I wouldn't begin to suggest that it wasn't. But nonetheless, it must be the case that it needs to be evaluated where you have a parent who's coming before the court. Of course, if you've got the circumstances in Re G, it must be done. But equally, we would submit it needs to be done if you've got a claim by a parent with whom the child is not living. It is a process that has got to be addressed by the court. And we would submit that there is simply nothing to suggest that the court ever applied its mind to the importance of the father in this child's life.
Although, once it's accepted that these issues were sufficiently elaborated in the evidence, then they at least said in paragraph 12, we place great weight on Mr. Williams' evidence. He's accepted by all parties as an expert. And then 13 issues not within his report have been covered by him to our satisfaction today. So, there is a limit to how much one has to elaborate one's reasons, presumably. But they could presumably have been asked for more reasons if that's what the criticism was. But they weren't.
There was a core balancing exercise to be done in this case.
Right.
One between the grandmother and her role and involvement in the child's life on the one hand, on the other, what the father had to offer this child and whether it would be in the child's interests to move to him.
Well, I know it's the pro forma again, but page 34 does have a heading halfway down about balancing exercise, and they do say we've balanced all interests in making our decision, and H's welfare is paramount. And, there's no dispute as to where the interests are, what the interests
Well,
are.
save that they are nowhere identified by the magistrates, and that is the problem. If there was some place in the statement of reasons where one could see that they had looked at the father's position, one would be able to deduce from that or infer from that that they'd put into the balance the father's position. But there is no process of evaluation that can be seen there.
This is a problem encountered in all types of contexts, where it can be shown that the tribunal has had evidence and has been presented with material, but hasn't recounted in its statement of reasons. And it's always a difficult case to make, I think, that a scrupulous tribunal, and apparently the magistrates have been commended for the conscientiousness here, simply because there's an omission in the recital of reasons in a pro forma which may be ill-suited to include this particular aspect of the case, whether we should conclude that on that account they cannot have taken it into account.
There is nothing that indicates that they have taken into account the fundamental other side of the equation.
Is this something that should be in the welfare checklist if one's looking at the pro forma again?
Well, one could, yes.
I mean, one could see that that it really is. I mean, the way you're presenting it at the forefront of your argument suggests it is in a case like this. But they're asked fairly general questions, and they give short and general answers. Anyway, I'm not sure we're going to get much more out of picking over the case at this level. We now move to His Honour Judge Richards. And what is your position about him? Are you maintaining that he applied his mind correctly to the task before him and applied the correct test, or do you accept that he misdirected himself?
We would submit that he correctly identified what had gone wrong in the magistrates' process, in the sense that the magistrates had not evaluated the role and the significance of the father here, the biological, psychological father, and the advantages to the child of living with the father. So he identified that the magistrates had gone wrong, and he did that correctly. I entirely accept that some of the language that he uses suggests at points that he may be elevating the child's interest, if I can use that in a neutral way, in living with a natural parent, to something like a right. Like, there are criticisms of his judgment that are made by the Court of Appeal, and I'm not going to attempt to go behind those criticisms and defend the course that he took. But I would remind the Court, and I know it's something that this Court's already been considering today, of what he did say when asked for permission to appeal. Which was at paragraphs 39 and 40, page 29 of the core bundle. I won't read them out again. I know this Court's read them this morning.
I mean, without paragraphs 39 and 40, you would be absolutely stuck.
I would have a more profound difficulty. Yes. Is it fair to say, well, the judgment comes to a full stop and that this is an afterthought? We would submit that's really not a fair approach. What he is doing...
Is there any chance that he would have changed his mind after paragraph 33, realistically?
That's a rhetorical question.
Well, my lord says that's a rhetorical question.
Well,
my lady, you have to answer. Yes, there is. He might have done.
Well, my lady, what I think I'd answer it the other way around and say that looking at paragraphs 39 and 40, where we would suggest he has stated a proposition that is entirely proper, one must give careful consideration to the advantages of a child being brought up by his natural parents. It's something that needs to be weighed in the balance at the end of paragraph 40.
40, yes.
Yeah.
Yeah. But then, well,
and having made it clear that it was the welfare test. at that point, there is nothing to... He is saying, well, that was actually the approach I've had throughout.
He doesn't resile from paragraph 30, though, does he?
Well, I think he's clarifying what his approach has been. The history of these cases does reveal how difficult the language is, how easily the word rights creeps into language when it is not meant as a parental right at all. It's an illustration, in a way, of the point that was made by Lord Justice Waite in the case of Kay, which is cited by Baroness Hale in Re G. And perhaps it's worth looking at in this context. It's at tab 3.
Paragraph?
And it's in paragraph 29. It's when she is reviewing the history of the development of these cases. And she deals, first of all, at paragraph 29, with what Lord Donaldson had said in Re H, when he talked in terms of there being a strong supposition, all other things being equal, it's in the interests of the child, it remains with its natural parents. And then goes on, talks about the case of Re W, also a grandparent-father dispute, and what Lord Justice Balcombe said. But then she went on to quote, and this was the passage that I had in mind, Lord Justice Waite agreed with Lord Donaldson's formulation and remarked, the authorities that have been cited by Lord Justice Balcombe illustrate the difficulty of finding, within the infinite variety of circumstances in which the welfare of a child may fall to be applied as the paramount consideration, some principle which does precise justice to the element in every child's welfare represented by the advantage of maintaining the ties of nature with its own parent. And it's been a difficult course to know how one formulates a proposition which one suspects accords with common experience and common sense, but how one moves that into a legal principle that applies in all cases and doesn't cross over the line of somehow becoming a right.
It's sitting there in paragraph 31 of G, isn't it?
Yes. Yes. Absolutely.
An attempt to do that.
Yes. Absolutely.
Paragraph 31 of G is subtly different from Lord Donaldson in the
yes.
H.
Oh, yes. Oh, absolutely.
Significantly.
Deliberately so, yes.
Oh,
Quite,
yes.
quite.
Yes, absolutely. And it's paragraph 31, which is, we would say, reflected in the way the judge has said he has approached it in paragraphs 39 and 40.
But not the way he approached it in paragraph 30.
No, absolutely.
And it's not
But
as
there's-
if paragraph 30 was alone, because he's building it up from
Yes,
paragraph 23
yes,
onwards.
yes,
isn't he?
he is. And I'm not going to try and justify the reasoning process. All I'm saying is that one can see why there are struggles with the language, but we would submit that what emerges at paragraphs 39 and 40 was when somebody says to him, look, you've really got this wrong. He's saying, no, I do know what I should be doing. It's welfare that's the appropriate test here, and you've got to give careful consideration to the advantage of the natural parent.
Just to be quite clear where you stand, you're saying that if you read the judgment as a whole, and by that I mean including paragraphs 39 and 40, whatever defects there may be in the earlier passages, the judgment as a whole was the correct one and should stand. Is that your position?
Have you applied the same approach to the paragraph 14 of the Justices' reasoning?
No, I'm harsher on them.
Where they say we have not found compelling reasons to disrupt the continuity of care. I mean, on that point, do you adopt the Court of Appeal's approach to that?
And going back to the Family Proceedings Court, the problem is there is absolutely nothing in the balance in their reasoning process. They talk about at 14 the grandmother being the psychological parent. They never discuss whether the father is or not. And then they talk about not finding compelling reasons to disrupt the continuity of care. If they had done an evaluation of the grandmother on the one hand and the father on the other, and then said, we have not found compelling reasons, it would be an exercise of their discretion, having done the proper balance. But we simply cannot see that the magistrates have ever done the proper balance. So that's why I am less forgiving, as it were, of them, because the judge, His Honour Judge Richards, did the proper correction process, and there's nothing to suggest that having, as it were, correctly stated the approach, to go back to Baroness Hale's earlier question,
But surely
would he have changed his mind?
even if they had analysed the first part of it, you suggest, surely the compelling reason is still not the test, because that's very much more like the notion of a strong supposition.
Yeah.
And if one was adopting Baroness Hale in paragraph 31, you wouldn't use the expression compelling reason. You'd say, well, indeed, as Lady Hale used the expression good reason, or something like that, which is different, I think.
Absolutely. It has to be considered and assessed, we would say, the consistency, predictability.
I think you've said that a few
I've
times.
said that several
Yes.
times, yeah. And so that's what we say about His Honour Judge Richards' approach. Having found that the magistrates had not correctly approached the case in the sense of directing themselves properly, he was entitled to exercise his own discretion.
So we go to the Court of Appeal.
And then we go to the Court of Appeal, yes. One thing perhaps I should just mention before leaving His Honour Judge Richards was that at page 26, paragraphs 19 and 20, he's setting out the history. So it's quite clear that he took into account, as it were, the security of placement factor. I call it that rather crudely. And on the other hand, there was the father's claim. And in relation to the father's claim, he points out at paragraph 20 that it was said by the social worker he could meet all H's needs and handle sensitively would be no reason why the transfer of residence wouldn't be successful. And indeed, that is clearly a factor that he takes into account if one looks at paragraph 31. Seems to me, on the evidence, handled sensitively, no reason why it can't be successful and father's able to meet his needs. So when he is doing the balance, those are the factors that he seems to be taking into account.
Yes.
The Court of Appeal then had to look at His Honour Judge Richards' judgment. They drew attention to criticisms that can be made of the way he described the law, which I don't attempt to defend, as I've made clear. Although they came to the conclusion that what he had done, and this is the essence of what they had to do, was to look at whether the magistrates had or had not applied the right principles when they were deciding the case. So once again, the Court of Appeal took as its starting point the magistrates' position, and they, like His Honour Judge Richards, thought that there are two defects in the way that the magistrates have dealt with the case, which I don't need to rehearse again, being the failure to deal with the father's role and what appears to be something that's almost elevated to a presumption of the what was referred to in the Court of Appeal, I think, in the course of argument, is the status quo argument.
So paragraph 42, that's the failure to examine the father's role. This is page 13. Paragraph 42.
Absolutely, yeah. There is no discussion by the justices of his father's role in H's life beyond the conclusion that the father and the grandmother can meet his needs. I'm not going to repeat the arguments that I've already made at length, but we do say that the Court of Appeal were absolutely right in that analysis.
But suppose they were. Then we have to go on to the next stage, do we?
Yeah.
Which is to look at their reasoning, their own reasoning in paragraph 64 and 65.
Yes, absolutely.
And paragraph 65 is a bit troublesome because on one view of their reasoning, it is that, or their decision, is that they concluded that the judge was entitled to interfere with the decision of the justice for the reason he gave, and that the outcome was not plainly wrong. Whereas, to my mind, at any rate, if the judge was wrong, then the Court of Appeal should have been exercising an entirely fresh discretion, starting all over again, going through the whole thing, just as the way you say it should be done. Yeah. Query whether they really ever did that, in which case they would be wrong too. And it would be, the next question would be what we should do about it.
And that takes us back to paragraph 62, where they identify the question, really. Do they dismiss the appeal?
Yes.
Yes, exactly.
Or do they remit it for rehearing? And that raises a question as to whether we should remit for rehearing.
In fairness to the Court of Appeal, in paragraph 65, just before the last sentence, they do say he exercised his discretion to achieve what we think was the right result.
Yeah,
so they're saying, well, they think he was right. That's their first point. Failing that, he doesn't seem to be plainly wrong. But yes, to pick up the point that's just been made, what happens when one might say, on one view of this case, that at no stage has the procedure been gone through in the way that one might hope? Yes. The magistrates have undervalued, not fully assessed or really addressed their minds to the claim of the biological father, have His Honour Judge Richards overvalued that, and has the Court of Appeal really done the balancing exercise?
Well, the impression I have from the careful way in which you've examined the AW's report and the proceedings at first instance, that suggests to me that, put it this way, you're saying that one shouldn't indulge in guesswork in matters of this kind. It's far, far too important. And the assessment needs to be carried out by somebody who's properly equipped and has seen the parties, you say, seen the individuals involved, and is in a position to make an informed decision. And that finds its way through to the magistrates at first instance. And the further remote you are from that process, the more dangerous I would have thought it would be to form views based on incomplete material, and that suggests that a rehearing is a very real possibility if one's going to reach a sound decision in a case of this kind.
Which perhaps leads on to the point about fresh evidence,
yes,
to which I have referred in my case. First of all, there is the simple point, but rather an important point, that the Family Proceedings Court order reduced the father's contact from a weekly overnight stay to contact once every 3 weeks. But, in fact, that didn't come into fruition. And since June and the order of the Court of Appeal, which
is page 19.
I think it's page 2.
Is it? Well,
Or maybe it's also at 19.
Maybe I
Which
got
case?
the wrong page.
Yes, 19 is His Honour Judge
I'm so sorry.
Richards.
Yes, you're quite right.
And of course, His Honour Judge Richards was making orders
Yes.
for the transfer to the father.
course.
But if we look at page 2, we now know what's been happening since, I think, the 20th.
Well, what happened?
11th of June.
What happened, in fact, on the ground between the Family Proceedings Court order in March and June?
May I just confirm with Mrs. Parnell? I think I know the answer, but I would like to make sure I've got it right. Yes. There was no change in the contact following the Family Proceedings Court order, so it remained once a week, staying with the father overnight.
So, as I recall it, H went to Dad on Friday and then to Mum on Saturday and came back to Gran on Sunday.
Yes, exactly.
So it was 5 days a week with...
And is that what's
Granny.
actually happened?
That happened until, I think, the 11th of June, when there was an order in the Court of Appeal.
11th of June.
And this is the order that's at page 2,
Yes.
in little paragraph C.
Each Thursday.
Contact between the child and father do take place on each Thursday after nursery until 4 p.m. on Monday,
That is 4 days a week.
4 days a week.
So in effect, the Court of Appeal had, in a way, preempted the situation.
And that's been happening.
Was that order made by consent?
Yes, it was made by consent.
Was it?
One of the days of the father's contact is in fact spent with the mother. So the present
Yes, I understood
regime
that, yes.
is 3 days with Granny. So she has
None of them weekend days.
No, she has him 4 p.m. on Monday until, I suppose, taking him to nursery on Thursday.
How many days a week does he go to nursery now? Or is he going to school now?
May I take instructions? He's at nursery for 2 days, I'm told. But grandmother may have more.
She may know better, may she not?
Absolutely, yeah. And then he goes to the father. And then on one day over the weekend, he spends 24 hours with the mother.
24 hours, not
Yes.
just daytime.
Yeah.
So it's an overnight.
It's one overnight with the mother. Then he goes back to Granny at 4 p.m. on Monday.
Is that after nursery? I mean, I really do need
yes,
to know
yes.
exactly what his nursery situation is.
4 days a week.
Sorry?
Total.
Well, you'll tell us, won't you?
I hope I will.
Miss Scriven will tell us the facts as she understands them to be, and then perhaps Miss Ball will tell us the facts as she understands them
Yes.
to be.
Well, my lady, what I'm told is that he goes to nursery all day on Tuesday and all day on Thursday, but doesn't go to nursery when he's with the father. 9 a.m. to 3 p.m.
So is he collected from nursery by father?
I
the
think
Thursday?
he's collected by Granny.
So the father.
There is, generally speaking, transport provided to grandmother to
Yes.
take him from the nursery.
So
And
he's
so-
collected from grandmother's house on the
That's
Thursday
right.
at 4 o'clock.
Yes.
So he doesn't spend a lot of time with Granny, does he?
No, no, no. He's now spending less than half the week
Yes.
with his grandmother.
Well,
So we've
there's
got a
obviously
completely different
quite a lot of
picture.
detail here if one was considering whether to interfere with the Court of Appeal's decision. Do you want to press this further at this stage? Or would you
Well, we
want to do-
obviously we have three types of decision, do we not?
Yes.
The first is whether on the issues of principle which we've been discussing, we allow the appeal.
Yeah.
If we don't do that, well, then we don't need to go into the next two. But supposing, simply for the sake of argument, that we do, on the issue of principle, allow the appeal, the question then is whether we exercise our own discretion afresh, or we decide that the justices got it right, in which case we revert to the justices' position, or whether it really needs a rehearing. So that's all of those questions are bundled into issue number 2.
Absolutely.
Issue number 3 is supposing that we decided that the case did need to be heard again, what do we do in the interim? The Court of Appeal, having basically brought about a state of affairs which makes... it was not preserving the status quo pending the appellate process, which is contrary to most principles.
Albeit by consent.
Well, I'm...
It doesn't actually record consent, I think.
It doesn't record consent, and I'm not seeing much evidence of consent.
But might I suggest...
Depends on the circumstance in which consent is given, of course.
But, Ms. Scrivener, as far as, I mean, it's extremely helpful to look at it in these 3 chapters. The first 2 chapters are things that don't require us to get into the detail of the current arrangements.
Absolutely.
And what I'm minded to suggest is that we consider, once we've concluded the argument, the first 2 points, and we'll ask parties to remain, and we'll adjourn and consider our position and come back, if we need to discuss the detailed question as to what we do if we're inclined to remit.
Certainly.
So your position would be, first of all, you say we should dismiss the appeal. I think that follows. And secondly, do I gather that you say there should not be a remit?
No, I think that it would have to be remitted.
You would accept there would need to be?
Yeah.
I think that...
I believe the whole of Miss Scriven's argument has actually been essentially directed towards persuading us of that.
Yes, it seems, well, if I may say so, it follows from the way you've analysed the AW from the very start. So I think that's a very sensible position to reach. And then, of course, we could look at the additional evidence, which we've not done and don't need to answer the points of principle.
Yes, absolutely. Because we would say that there is also fresh matters that would need to go into the melting pot for analysis, if I can put it that way neutrally, as well as the fact that, of course, on the ground, the arrangements for this child have now changed.
Well, is there anything more you'd like to say on the first 2 chapters, bearing in mind that if we get into detail, we'll come back and discuss them with you?
Could I just ask one question, which is a remission to whom? On your submission?
Yes.
If there is to be a remission,
Yes.
who would you submit it should be remitted to?
There has been some discussion amongst the bar about this. It seems to us that it could either go back to the Family Proceedings Court or to the County Court if it was thought that that was a more appropriate level at this stage. But perhaps when and if you reach the stage of wanting to remit and looking at fresh evidence, there will be a better evaluation of what level it needs.
Finally, if there is a remission, in the ordinary case, would a judge expect to remit it, to consider the remitted case on the basis of whatever the evidence was at the time of remission? Yes. Or would the judge only be considering the position as it was when it was before the magistrates?
Absolutely not.
Yeah. Surely. And would you not have a fresh Section 7 report?
It would be a complete rehearing with hearing all the evidence again, as at the time when that judge had to.
That's what I thought.
Yes,
in
that's
this
what
case,
it should
the fresh
be.
evidence point's irrelevant, that is.
Well,
Yes, that's right. If we think that the right course is to remit,
You don't.
that's why I haven't read the fresh.
Absolutely.
It did not seem to me that it was necessary to do so at this stage, because it's either we think that the Family Proceedings Court got it right enough, or we think that the whole thing needs to be tried again. Those are really the 2 options, on the assumption that we are against you on the issue of principle. And
I think all that I would say about the fresh evidence is that because of the fresh evidence, we would say that it it should be remitted even if without it
Yes.
you had come to the view that it did not need to be.
But
So,
you-
that could perhaps be looked at a later
But you could have
stage.
made a fresh application to the first instance court on the basis of this sort of material, could you, for variation of the order?
There could have been, but of course it emerged whilst the appeal process was already
Yes,
going.
yes, but in principle.
Yes,
Yes.
Absolutely.
I think
If there
it
hadn't,
question-
if proceedings had been completed,
Yes.
It must be a
yes.
question of degree anyway, just how significant
Of
the new
course it
material
is,
is. I
yes.
mean, obviously some are so crucial that would have to go back, but I'm not sure whether it's in that category.
No, absolutely.
Well,
To be thought about.
can we leave the matter there as far as your submissions are concerned, unless, Mrs. Parnell, you've anything you would like to add?
And subject to this, can I assist in any way about the rather more peripheral issue as to the calling of my client's wife, which was one of the points that had been raised? I suspect it's not going to be of central concern, but if it's of interest to your lordships, then ladyship, I shall.
Sorry, I haven't
course,
quite
develop
grasped
it.
the point. Calling her?
She wasn't called.
She wasn't called as a witness.
Oh, I see.
Family
Yes.
And didn't do a statement.
Right.
And there was some criticism being made of that fact.
Yes.
But
Well, in
it's
fact, the
probably-
criticism could be made on each side. I mean, your side could say, how much the magistrates would have helped to see what a splendid person the father's wife is.
Yes.
The grandmother could say how much they would have been helped to see that she was actually preoccupied with her brand new baby and her 4-year-old daughter.
It wasn't a case, in fact, where there was ever any criticism of her as a
It's
prospective
not a question
carer
of
anyway.
criticism, is it? It's a question of
Yeah.
back to what you were saying before.
Yes, it is. So unless I can assist with those other matters that have been raised, there's nothing that I think I can assist you with.
Thank you very much indeed. Now, Miss B, if I may address you as that for obvious reasons, you've been listening to the argument. There's absolutely no need for you to say anything at all unless you'd like to. But if you'd like to say anything, you have an opportunity of saying something.
I just want what's best for my little boy.
Yes,
That's all I want.
right. Thank you very much. Yes, please.
Well, my lord, to concentrate on the matters that you were mentioning a few minutes ago, unless you want me to go any further, I was going to answer some of the questions about the Court of Appeal and the contact for a start. I'm told by Mr. Horrocks, who appeared in the Court of Appeal, that the terms of contact were on the basis upon that is what would be ordered.
Can you try and address your remarks to the microphone?
I think it helps
It
if-
doesn't help
sorry.
us very much, or even the people at the back of the court, but it does help the relay in the other places.
It's also better, I think, to use the lectern, because that gets your, if I may say so,
Yeah.
gets you standing up
Quite
a bit
right.
straighter, which is probably better
Yes.
for voice
Can we
production.
activate this microphone as well, please? Because I think that
Gone out again.
Yes, can we begin again, I think?
I was simply going to say that in answer to your question about the contact order that was made by the Court of Appeal, if I may answer that part first, it was not by consent. Mr. Horrocks appeared on the part of the grandmother on that case. It was granted on the basis that these are the terms of contact upon which a stay will be granted.
Yeah.
Right. So the Court of Appeal was only prepared to grant a stay on the basis
Of that type of order.
of that type
Yes.
of order.
Yeah.
On the issue of fresh evidence, the problem with that is that the fresh evidence, which I won't go into, of course, is responded to by the grandmother, and each element of that fresh evidence is disputed in one form or another. And so one immediately gets into the area of saying, well, there are possibly issues here that may need to be looked at. It was raised by one of your lordships that can this not be done by way of a variation order in the court below, whichever court below it may be, with a fresh CAFCAS or Section 7 report. And my answer to that is yes. That would in fact be a very neat way of doing it. If your lordships were to decide to allow the appeal and not remit, because then the father would be left to make that application which he could then do using his fresh evidence. And that would be a matter that would then be contested. I suppose what I'm pointing to is that if you're concerned, my lords, my lady, that there is fresh evidence that needs to be looked at, it can in fact be looked at in two different ways. One is by remitting it to be heard again, if that is the way that you feel it's correct to do so, or else dismissing allowing the appeal, at which point the father could, in fact, relying on his fresh evidence, make an application in any event in whichever court below was appropriate. So we are not losing that fresh evidence, whichever course you take. It can be looked at. I must simply point that out. Obviously, we believe and submit to you that you should allow the appeal and let the matter then take its course, for the reasons that I've set out at length in my papers to the court and discussed and debated this morning, which I don't know whether you want me to pursue in any way, following Ms. Scriven's address to you.
Well, I'm not sure there's much dispute between you on the fundamental point of principle. No. There's obviously some considerable dispute about how you analyse the, first of all, AW's report and then the decision by the magistrates. But we've heard a lot of discussion about that, and unless you have particular
I don't think I have
points,
anything fresh to add to that. I think it's in my papers, or has been addressed by me, or has been addressed by Ms. Scriven. Can I simply correct one point of fact? And that is that Ms. Scriven says that, said to you this morning that, in fact, which I don't know whether it's going to be considered relevant or not, but that the child had spent 20 days with the father, and that was established in the court below. In fact, I do have the page reference to that piece of evidence, and although that is what the father said, the grandmother said, it's page 136 of part 2, that it was 4 or 5 days that the boy stayed with him when she was ill. So there isn't any agreement there.
so it's 4 or 5 days
4 or
on one
5 days
hand.
on grandmother's side, and 20 days on father's side.
That was page 109, I think, or something like that.
136 was mine. Was it 109?
136.
136 in my case.
Yes.
And further, it's in his statement, appendix part 2, page 278, paragraph 37, is where the father talks about it.
Thank you very much. Yeah.
2 days a week, apparently after half term there's a change in arrangement. It's more
Well, I had the wrong information, and can I apologise for that, because my client is not here today, and that's no disrespect to this court. Her mother died last week. She is looking after Harley, and in fact we didn't think that it was absolutely necessary to be here. So I'm rather having information relayed to me, and I apologise for that. Apparently it's 2 days a week now to nursery, and 4 days a week probably after half term, which is coming up in a week or so's time.
Yeah.
When you invite us to allow the appeal and simply allow the Family Proceedings Court order to stand,
Yes.
of course there are 2 elements to that, one of which is the residence order,
Yes.
but the contact order, of course, reduced the amount of contact the father was already having.
Yes.
Now, you may not be in a position to answer this, you may not have instructions.
My recollection of reading the papers, if it's any help, and of course I wasn't there, is this. It was felt by grandmother, and I think supported by, I believe, by Mr. A.W., that the constant change around was not actually helpful to the child. The grandmother proposed, and I believe this is what was followed, that if there was a rota whereby it was, for example, father one weekend, granny second weekend, mother third weekend, granny fourth weekend, and then round again, that would be less disruptive to him. And I think that it was along those lines that was granted. Thank you very much.
Page 21.
Yes. I remember the discussions that appeared to have taken place in the evidence when I was reading it, and that seemed to be the gist of it.
Now, I could
And that was
perfectly well see
why.
the reasoning behind
Yes.
the order, but of course, and this may not be the right time at which to discuss this, but we are now in a different place.
Of course, I understand that. One of the problems about the fresh evidence arises out of, and I'll say no more than this, the very fact of that new contact order. And that appears in the documents that you haven't seen and may not see. But it is certainly a matter of considerable concern to my client.
But you would say, I need to get this straight in my head, there is no need to remit this case for a new trial.
No. Yes.
Because the justices did have all the information that they required, yes, and they considered it properly. And to the extent that they didn't say genetic fathers are important for the following 3 reasons, that's common knowledge and can be taken for granted.
Well, that's common knowledge and common sense. They had a lot of material which came out in the evidence. It's been rehearsed in the course of this hearing. 1 or 2 parts weren't perhaps gone into as much as might have been if I can just refer you to them. But, for example, in evidence, Mr. W said about identity, many children don't live with parents who manage quite well. Impact on the child's identity is when adults don't work together, much more significant. He also said, that was at page 109 of part 2. I'll just give you the page references. In oral evidence, he also said that the impact upon the child of not living with his his father, it's 121, I don't want to misquote it, so if I give me a moment, I'll find it for you.
Well, possibly the most important one is on 109, where he said it's appropriate for the child to live with biological parent wherever possible.
Yes. But also, I feel it's put to him that children picking up from school and so forth, you don't address that. I feel that you're overstating that. There are many children not picked up or living with their parents. Key issue, can the adults work together? That's 121. I think it's probably the similar one to the one I just quoted. And also at 126, talking about contact issues, contact will address the identity issues. He knows who his mum and dad are. It's about 10 lines down from the top. Do you agree that this contact person would address the identity issues? Yes. There is no issue that Harley is not aware of who mum and dad is? No. So the whole issue of his identity needs was before the court, although in dribs and drabs, if I put it like that, coming out in the evidence. I can just turn to... Yes, 109... It seems, both from those small pieces, but all the other things that have been discussed today, such as looking at the significance of the father in grandmother's life, has good relations with mother, father, grandmother, who are all significant. Father and grandmother can lead, has good relationships with all the parties, contact has worked well historically. There is a thread running through that case where the issue of father's part in his life is being addressed. And I suppose what I'm saying is they clearly would have had it in mind. It was a common sense and obvious aspect. Here was a father who was offering to look after his child and against the grandmother. They were perfectly well aware of it. Did they need to spell it out in terms? And we would say no. And the latitude that is shown quite generally to other judges should have been shown to them, bearing in mind the type of pro forma reasoning that they are expected to give. I've been through it before, I'm not going to repeat myself. But those are my points. Is there any other question?
Could I just ask on the matter of geography? This is all in an area in East Anglia. Yes.
Quite close. Can I just turn to my solicitor, who's the person who has the geographical knowledge?
It may save time later if I ask now.
Certainly.
I did wonder about that, whether the distances. I don't think there are, judging by what we've been told. Do you? So they're fairly close together.
A lady, I don't know if it would assist, but my client who does the driving says I think it takes 45 minutes to an hour.
By car?
By car, between his
see.
home and grandmother's home.
I'm told it's 37 miles, to be precise.
37 miles
and
between...
father drives.
And
And father does drive, my
further
client.
7 miles between grandmothers and fathers'
That's what I understand.
homes. And where is the nursery?
Close to mother's, as I understand it. My client lives in a place called Rentham, and I believe the nursery
Close
is
to
in there.
grandmother's, did you say?
We're just trying to be as careful as we can.
Sorry. Well, yes, it's close by, in that area.
Close to grandmother.
To grandmother's, yes.
Yeah.
He's always attended that nursery since he started nursery, and of course he always lived with grandmother, so that's where he started and that's
Yes.
where he remains.
And he's now getting on for 4.
Yeah, before the beginning of December, 12.
But the plan would be for him to go to a school, presumably, quite soon.
Quite soon, Rising 5. I'm not quite sure when the intake for that would be, whether it would be January or whether it would be, I should suspect it will be September for a December child. I should have thought, but I'm afraid I'm only using
Well,
my
I've
own
asked the
knowledge rather
question,
than-
if it becomes
If it's-
relevant.
If it's different, I can
Yes.
pass you a message.
It may not become relevant, but if it becomes relevant, it will be.
I'm told that the nursery is about 3 miles from the grandmother's.
3.
Well, what we propose to do is to retire and consider the position. We'll do our best to reach a decision this evening. I think we feel under a considerable duty to do that in everybody's interests. And when we've reached a decision, we'll come back. And if there's more to discuss, we'll discuss whatever needs to be discussed. So would Council and those behind them please remain so that we can be provided with more information if we need it and more submissions if we need them.
Of course.
We'll be back as soon as we can.
Right, they've gone for a short journey. All rise.
Well, first of all, I should say the court is extremely grateful to counsel on both sides for their assistance, both senior and junior, and those behind them. It's made our task rather easier than it might be, although it's obviously a very anxious case. Our decision is that we must allow the appeal, and that in consequence the order of the Lowestoft Family Proceedings Court of 6th March 2009 will be restored, subject, however, to an order by this court, the terms of which Lady Hale will explain in a moment, which will remain in place for 6 weeks until the 27th of November 2009. Now, I'm going to invite Lady Hale to tell you what the proposed order will be, and she'll explain the reasons for it, and also that there's an opportunity to comment on it if you have comments to make.
Thank you.
Yes.
The reasoning, of course, is that the matters have been altered by the Court of Appeal's order this June, and we wish to soften the transition for Harley back to the state of affairs as it was after the magistrate's order, and we acknowledge that it is open to the father to make an application to the Family Proceedings Court for the variation of the order of the 6th of March this year. And for that purpose, for this limited period of 6 weeks, we propose that the grandmother shall allow H to have contact with the father from 4 p.m. on Friday to 9 a.m. on Monday, beginning this Friday, the 16th of October, as I say, lasting until the 27th of November. We also propose that during that period, the father shall allow the mother, shall allow the child, H, to have contact with his mother for such period as they shall agree between them. As we say, this is the thinking behind this is that it is to contract the weekend with the father that was ordered by the Court of Appeal, to allow for the possibility that the child may be going to nursery for more days a week after half term than he is at present, and to give the father the opportunity of making an application for a variation should he be so advised. We are also conscious of the fact that the parties have, in the past, been able to agree arrangements between themselves. Despite all the battles that they have with one another as adults, they seem to have been prepared from time to time to acknowledge one another's strengths and make their own arrangements. And it is always open to people who are caring for children to do that. It is the very earnest wish of this court that the parties would be able to do so.
Thank you very much. Yes.
yes, indeed.
Now, Ms. Moore, what I said at the outset was that this was subject to any points that you wish to raise, and indeed Ms. Scriven would wish to raise. Do you have any points to draw to our attention? We appreciate the problem you have that you don't have the grandmother present, but are there any points you want to make?
Several telephone calls have been made in your absence, so that I could confirm for sure what position.
Could you speak up a bit, please?
Yes, it keeps
It's not
going.
on.
I think I'm leaning against it.
Yes.
Little yellow button.
Yes, I'm afraid it's right in front of where I was standing. Is that better now?
Yes, it is.
Several telephone calls have been made while you were out to ascertain the position over nursery and primary school. And the position is that the grandmother has recently got additional funding which will enable a slightly longer at nursery. Not a great deal longer, but a certain amount longer. Because as I understand it, the government maximum assistance is up to 15. She has, I think, 12, and she's got another 3. And it's a question of allocating an extra half day on that. But in addition to that, I am told, again through telephone calls, that there are going to be 2 or 3 days available from after half term at the local infant school, which is a walk away from the nursery. And the only reason that that this hasn't really been looked into properly before is that the contact just overlapped into the week and it couldn't be done. But it is her intention, if Harley is to remain with her, to fix up as much as she can in the week for him, and it'll be made up partly of nursery and partly of infant school.
Can you tell us which days would be affected then, and the timing? Presumably, it wouldn't be, and if it was a Friday, it wouldn't be lasting beyond 4 p.m. on the Friday.
I don't think the school would in any event at this age last beyond that time.
But the Monday?
But at the moment it's Tuesdays and Thursdays for sure. Those are the ones that are in existence. Can I just ask Eugene if he remembers, what was the extra day? I think that the problem about the extra day is that the headmistress, a head teacher at that nursery, is actually on leave until next week, and it's not been allocated, the extra half day or whatever is going to be available at the nursery. We don't know. I have nothing on here about which days it would be at the infant school, and I doubt very much if she knows that at the moment. But it could be made quite clear to her that she is to avoid the days that you had.
But in principle, we've said that
Freed it up.
H spends all the weekdays with her, and part of the thinking was to accommodate that.
Yes.
But this is only a transition to try and...
Yes. From your order, the 6-week order, there would still be no weekends at home at all.
This is true.
As I understand the position to be. That, I think, is something of a problem, but I'm obviously not here to make an application for contact before you.
No, well, it's been stressed. It's a transitional...
It is a transitional point. And
it's purely transitional. It will revert to the March order, or whatever variation of the March order the parties can agree, unless the father makes an application to the Family Proceedings Court and persuades them to vary their March order. So it's simply for those 6 weeks to give that opportunity to the father.
I don't have instructions, but I'm sure that her earnest wish is that the child does start the extra days at nursery. He enjoys it very much, and hopefully he will school too. So I don't think I'm in a position to say any more than that. I thank you for allowing that to happen. I don't think I have instructions to go beyond that.
No. Ms. Scriven.
I appreciate thinking is that there's a 6-week transitional period, and clearly the father will have to consider what, if anything, he is proposing to do. May I say this? I gather that a return at 9 o'clock on Monday morning is difficult because the other child of my client's wife has to be taken to school at 9 o'clock in the morning. She works, and so it is the father who is at home and takes the child to school, but he could obviously return H, I would have thought, after... Well, can you find out what they suggest? I gather he's only got a provisional licence. I hadn't realised it was complicated by that fact. So may Miss Parnell take some instructions about the practicalities of return, having told you about the difficulty of a 9 a.m. return on...
I think what we would like is if it's possible to have a time proposed. I mean,
Yes,
if it's to be 10
absolutely.
p.m. or 11
Yes,
p.m.,
exactly.
then we put it in. Sorry. Yes.
Would you mind if that
Should we
process goes
retire?
on?
And possibly you would have a little bit of a chat with
Absolutely,
Ms. Ball
yes.
about it as well.
May I also say this? The nursery funding, we understand, will cover another 3 hours of nursery a week, so that doesn't seem to make for any fundamental change. And as far as starting preschool is concerned, bearing in mind this is a sort of holding arrangement, may we suggest that it wouldn't be appropriate to start at preschool at this stage without knowing where the child's future is going to be?
We know where the child's future is going to be. We have restored the order of the Family Proceedings Court.
Yes, yes.
We contemplate that the contact order that was made by the Family Proceedings Court has never been put into effect. And in any event, of course, the dates on it need changing. That can be done easily by agreement between the parties. But we were conscious that it was a very big change from the order made by the Court of Appeal to the order made by the Family Proceedings Court. Technically, of course, we are only therefore trying to soften that transition. Where this child's future lies is as decided by the Family Proceedings Court, unless and until some other court having jurisdiction to do so changes it. We just contemplated that the father might wish to agree a variation, and the mother might too, a variation in the contact arrangements that were laid down in that, because that gave him less than he had been having before. So that's the thinking.
Yes, I
It's not,
appreciate that.
we're not talking about uncertainty as to where this child's future lies. Unless and until somebody puts that into uncertainty.
I think the suggestion is that we should retire again for a short period
Yes,
to allow
yes.
you to take further instructions. But could I say to Miss B, is there anything that you want to say about the practicality of what has been proposed, or would you like to have a conversation with counsel for the father? And if there's any points that you would like to make, you could explain them to them, and I've no doubt, Miss Scriven, you can explain them to us.
Yes,
And that might be the easier way of doing it.
Okay, thank you.
Is that all right? Well, we'll adjourn just for a while, and I think, can I suggest we come back in 15 minutes' time, and if you need longer, let those behind us know.
Yes, of course.
Yes.
All rise.
Yes, Miss Scriven.
May I deal with practicalities
Yes,
first
please.
and then another point after that? The practical problem with a return at 9 o'clock on Monday morning is this. My client's wife works from 7:30 a.m. until 3 p.m. She is the one with the full driving licence. My client only has a provisional licence, so he is not able to drive until she's finished work. So on Mondays, it would not be practicable for the return to take place until 4 p.m. The grandmother was disqualified from driving and doesn't drive. I don't know whether there is any other person who might be found who could effect a return. We haven't been able to establish that in the time available. But a 9 o'clock return is if the responsibility is on my client, not going to be something that can be achieved.
But presumably Sunday evening would be achievable.
So, Sunday evening would be achievable.
Yes.
Yeah.
That, of course, makes for quite a tight weekend as between the father and the mother.
Yes.
Yes, we realise that, but we're needing to contract this weekend in the most graceful way possible.
So that's the point about transport. May I raise a second matter for clarification purposes?
Yes.
And that relates to our application to adduce fresh evidence. Should we understand that this court has considered that evidence and decided that it does not affect the decision, or has this court taken the view that if there are fresh matters, they should be, if it is thought that they are of sufficient importance, be matters that should go before the Family Proceedings Court?
It's the latter. I mean, the position we take is that we can't assess all the evidence, and
Yes.
if there's a point to raise, and I hope we made it clear earlier on that it's up to the parties to make their application to the court and to the family court, and if your client doesn't understand that, he should certainly feel that he has liberty to do that, but it's not to come to us.
I'm only asking for clarification because, of course, one wouldn't want to be in a position in the Family Proceedings Court if an application were made, and I'm not saying one will be, but should an application be made, where they were to say, well, this material was before the Supreme Court and was obviously considered by them, because that's, in fact, not the position as I understand what's being said.
We'll make that clear when we give our reasons.
Thank you very much indeed.
Thank you.
That was the point of
Thank you very
clarification that I thought. Thank you.
No, Miss Ball.
Well, I have very little to add. We were prepared to agree until we were told that 7:30 to 3 was an impossible time for delivery. We were prepared to say 9 or thereafter, as can be agreed between the parties, thinking 9:30, 10, something like that. Told now that's not possible. I have suggested to my learned friend that Sunday evening would presumably be the other alternative, and that is what I'm proposing.
Have any suggestions or information about when the child normally goes to bed? I mean, we've got to consider his interests.
No, I don't have that. I don't have that information. But he's a child of 4, nearly 4, and I suspect he should be back by 7 at the latest.
Yes.
And that's just a guess from other cases and my
Like
experience.
6.
Perhaps even 6, but it's between 6 and 7.
Yeah.
Yes, if we were to say between 6 and 7 on a Sunday.
I think so.
Proposal.
Yes, I think so. It shouldn't be any later. That's the point to make. Yes. Well, we're very grateful to Council. What we propose to do is to issue our order, and we'll give our reasons later. The order should be available, I think, later this evening, so that you can collect it from us, from registry, and take it away. And our reasons will be given as soon as possible, and certainly within the 6-week period, so that the court and Lowestoft has the information before it.
Thank you.
Should, of course, that court become seized of this matter, we made it clear, of course, that we're not remitting the case. It's
The court will now adjourn.
Because on the internet.
I do.